While some people are still joining. Welcome everyone to the second day of our joint conference between the Federman Cybersecurity Research Center and the Haifa Cyber Research Center, dealing with regulation of quasi-sovereign cyber and tech powers. Our upcoming panel will deal with regulation of artificial intelligence and cyber capabilities in the battlefield. We are delighted to host three distinguished speakers which will bring their unique perspective based on their different experience. Our first speaker is Dr. Cordula Droege, who is the Chief Legal Officer and Head of the Legal Division at the ICRC. Cordula worked in different capacities in the ICRC, most recently as Chief of Staff to the President of the ICRC, and earlier for the International Commission of Jurists and the Max Planck Institute for International Law. Our second speaker is Dr. Yahli Shereshevsky, a postdoctoral fellow at the Federman Cybersecurity Center, and starting from the coming academic year, a professor of law in Haifa University. He has been teaching international law and other courses at the Hebrew University, and has instructed for many years students for the IHL competition organized by the ICRC in Israel. Our third speaker is Dustin A. Lewis, the research director of the Harvard Law School program on international law and armed conflict. Mr. Lewis leads research into several wide-ranging contemporary challenges concerning armed conflict, with a focus on international law sources and methodologies. Mr. Lewis heads the research for the project International Legal and Policy Dimensions of War Algorithms, Enduring and Emerging Concerns. Now, without further delay, we will turn to our first speaker. Cordula, the floor is yours. And
thank you very much, Tal. Thank you. And thank you for inviting me to speak on this panel. I'm very happy to be here, see old friends. I want to say though, before I start, that perhaps we might find it a little incongruous to speak about new technologies today, given the violence that surrounds many of those of you listening in on this discussion. So I want to say how much this causes me pain, because I've also lived a very short while in your region and I've come to love it. It's also, I think, a reminder that ultimately today civilians bear the brunt of conflicts, and that while IHL can only ever put a very little plaster on a much greater wound, that is the absence of peace, if it isn't respected, civilians will pay the highest price, and all the more so in densely populated areas. So I just wanted to say this because it seemed odd not to acknowledge the situation in which you are. Now, to the topic of this panel, that's the influence of new technologies on the regulation of the use of military force. And I've been asked to focus on the role of technology in inviting and reinterpretation or reevaluating of existing IHL norms and possibly the need for legal reform. So before turning to two specific technologies, cyber capabilities and autonomous weapon systems, I'd like to say a few words on how these technologies are anticipated to change trends in warfare, what the humanitarian consequences and risks might be, and what the general legal position today is. So first point of introduction, how does or will new technology change warfare? Military and technological experts anticipate quite fundamental changes in every domain. So undersea, outer space, cyberspace, along the electromagnetic spectrum. And from a humanitarian perspective, what this means is additional layers of damage and destruction, and basically new domains of vulnerabilities for civilians and civilian infrastructure. So for instance, every connection to the internet is for civilians a new entry point, of course, for a possible attack or a possible vulnerability. And so it goes on. Information technology, which underlies, of course, what we call cyber or artificial intelligence, machine learning, and so on, is dual use. And so that means it will develop fast. It might be relatively cheap, or some of it, and that also means a great risk of proliferation. And here again, from a humanitarian perspective, proliferation means wide availability of weapons, which, as we know from experience, is a heightened risk for civilians as well, in war, but also in all other situations. New technologies also are anticipated to increase the speed and scale of warfare. And this isn't only an issue which is much discussed about international security, but it's also an issue for the use of force. Because the risk here is that you have less human control and judgment at the time of using force. Now, what does this mean in terms of the law? I would perhaps say three things. The first one is that IHL rules set constraints on all new technologies, weapons and methods and their use, as confirmed, of course, by the International Court of Justice in the nuclear weapons case, recognized in Additional Protocol 1, but also recognized really widely by states. So nonetheless, although IHL applies to all new technologies, certain emerging technologies may demand clarification of the law or even new rules, taking into account their impact and legal and ethical considerations. Military technologies are pursued for military advantage. And from the point of view of the ICRC, of course, the concern is to find the balance between military necessity and humanity as IHL requires. And when we assess new technologies of warfare, what is very important is that we have a realistic approach to it, particularly when there are uncertainties about technologies and how it will be used. And what we have to do then is really to look at the big picture of how new weapons are actually or are likely to be used in today's types of conflicts. So we're talking about urban warfare, we're talking about protracted conflicts, we're talking about conflicts which will involve and continue to involve some non-sophisticated parties. By 2050, 2/3 of the world populations will live in cities. And with people, war will continue to move into cities. And so when we think about new technologies of warfare, we really have to challenge narrow scenario-driven thinking about the perfect new technological weapon, and question claims that imply that new weapons and methods are necessarily going to benefit for compliance with IHL. They might, but they often will not. So with that, by way of introduction, I'll turn to two specific technologies. And here too, I'll try to look at the risks from a humanitarian perspective and whether IHL how IHL would apply to it, how could it be interpreted or not, and whether there's a need for new rules. First, cyber capabilities. Cyber capabilities, of course, are already being deployed in a wide range of contexts, mainly outside of armed conflict situations. And so they also have a wide range of consequences that already exist, sometimes outside of conflict, and there are a lot of potential consequences, of course, as well, that we might not have seen yet. Often, when we talk about cyber operations, or rather when states focus on cyber operations, it's very much in the realm of risk to societal and political processes, even values sometimes. Very often there is concern with misinformation, disinformation, and hate speech. And these are important humanitarian concerns. And of course, hate speech can sometimes cost lives, and we need to be cognizant of that and probably dig a bit deeper into what that would mean in situations of armed conflicts. We know a bit of it, of course, from international criminal law in particular, but I think that's a field that needs more exploring. In this particular case, I'll focus more on risks that are more traditionally addressed by IHL, and that is the disruption or destruction of civilian infrastructure. So just to give an example of, or some examples of what we have seen so far, mainly outside of armed conflict situations, but can just as easily happen in armed conflict situations. So as you know, for instance, during the COVID pandemic, we've seen many, many cyber hacks of hospitals and other health infrastructure. They have actually multiplied. And when you take that trend in parallel to the trend that we have in armed conflict, where there are a lot of kinetic attacks against healthcare facilities, it clearly shows that there can be a great risk for health infrastructure through cyber operations. And then, of course, you know, they're having very serious attacks on industrial systems. Industrial systems are very resilient because they are built in a way that will sort of catch, you know, another bit will catch when one bit is disrupted. But still, when you think about, you are all familiar, for instance, with the Stuxnet attack on the Natanz nuclear facility in Iran back in 2010, more recent reports of fires and disruptions in Natanz. In February this year, a computer hacker gained access to a water system of a city in Florida and tried to pump in a dangerous amount of lye. Just last week, I think it was, or 2 weeks ago, we had the hack on the Colonial Pipeline in the United States, which has been considered one of the most significant attacks on critical national infrastructure. This pipeline transports nearly half of the East Coast fuel supplies. So you can easily see how that can, despite the resilience, still carry a great risk of disruption. And now when you think about, of course, industrial systems in places which are perhaps a little less resilient than in a place like the US. We've seen the cyber operation in May of the Iranian port. There was an attempted cyber operation against some Israeli rural water systems. And there are, of course, also numerous cyber operations every day destroying data on both state and private computer systems. And the list goes on. So in terms of international humanitarian law, I will mention 3 questions that we have to ask ourselves. There are many more, but I will just use these 3 by way of illustration. The first one is that the rules on the conduct of hostilities in international humanitarian law, so distinction, proportionality, and precaution, are attached to the notion of attack. And attacks are defined in international humanitarian law as acts of violence against the adversary, whether in offense or defense. And there's a debate among scholars and states on whether cyber operations that disrupt the functioning of computer systems that underlie infrastructure amount to attacks or not. Some scholars and some states say that they don't, because these are not considered acts of violence that have an effect of physical and relatively permanent destruction of infrastructure, but they are merely computer operations that disrupt infrastructure and therefore are not seen as acts of violence and therefore not as attacks. Other states and scholars and experts take the view that if you look at it from the perspective of the object and purpose of what international humanitarian law is trying to achieve, which is to uphold the principle of distinction, proportionality, and precaution, then you have to see these also as attacks, these cyber operations triggering the rules on the conduct of hostilities. Now, whether you need new law or not then depends, first of all, on your standpoint, and secondly, on how you interpret international humanitarian law. If the object of your interpretation, and which I think is one of the underlying objectives of humanitarian law, is to protect civilian infrastructure, then you have to ask yourself, well, if such operations are not considered attacks, then what would protect civilian infrastructure? So if you take the case of the oil pipeline, it was only disrupted, it wasn't destroyed. Was it therefore, could it be, if it happened in an armed conflict situation, be considered a direct attack on a civilian object or not? And if not, then what is the rule that would prohibit this attack? And there are various answers to this, but it's relatively unclear. Secondly, there's the question of proportionality. There are questions around proportionality because much cyber infrastructure is dual use, meaning it is used both for military and civilian purposes, underwater cables and so on. And so if part of a cyber system is used for military purposes, then normally the entire object, at least in the traditional view, becomes a military object. And so the question then arises of how to protect the rest of the civilian use of such infrastructure, which might be most of the use of such infrastructure. And again, depending on how you interpret the principle of proportionality, you might come to the conclusion that international humanitarian law is sufficiently protective or not. Third is the question of civilian data. One of the greatest danger, of course, of cyber operations, and this has happened, of course, in many cyber operations, is the destruction of data. Now, under international humanitarian law, there is, of course, a prohibition of attacks on civilian objects. The question is, are data objects? And traditionally, and that includes, for instance, the commentary of the ICRC commentary to the 1977 additional protocol rule, speaks of objects as tangible things. And that is not the case, of course, for data. And so here again, there's a divide in interpretation, with some states considering civilian data to not fall under objects, under the definition of objects, and other states considering that it does fall under objects. And again here, depending on whether or not you can protect civilian data as objects, you have sufficient protection in armed conflict situations or not through IHL. So these points just to illustrate that the reinterpretation and reevaluation really depends, well, or let's say the reevaluation on whether new law is needed, at least from the perspective of the protection of civilians, depends a bit on the question of interpretation. Given the uncertainties around these questions, you may argue that at least an authoritative interpretation by states, by a large number of states, or indeed new law might be useful. On the other hand, we also know that the political divide around cyber operations, cyber warfare, cyber competition, as it were, is such that no new law really at the international level seems to be on the cards at the moment. You know that there are several processes at the United Nations. There's an open-ended working group. There's a group of governmental experts that are working on these issues. And there isn't even among states an agreement that international humanitarian law applies to cyberspace. Not even that. And so from there to wish for new agreement that would be sufficiently protective of civilians is probably at the moment still a prospect that's a bit wider in the future. Then I'll turn lastly to autonomous weapon systems. So the ICRC understands autonomous weapon systems to be weapons that select and apply force to targets without human intervention. So it means that after the initial activation or launch by a person, the autonomous weapon system self-initiates or triggers a strike in response to information from the environment received through sensors and on the basis of a generalized target profile. So in simple terms, autonomous weapon systems are weapons that fire themselves when triggered by an object or a person at a time and place that is not specifically known nor chosen by the user. So the defining feature is really that autonomous weapon systems are triggered by their environment. And you might even argue that, for instance, a landmine is an autonomous weapon system. Now, the autonomy in weapon systems can be implemented with a wide variety of weapon systems that already exists, with a wide variety of munitions, especially unmanned systems that are at present still remote controlled. And many of those remote control systems can already identify, track, or select targets autonomously And so it's only a small investment, a software upgrade, or even just a change in doctrine for these to apply force autonomously. The military benefits of such weapons and why much is invested in these technologies are several. Increased speed, of course, and I mentioned that before. Automated area denial, so that's a similar logic to laying minefields, for instance. Continuing an attack when communications are denied, and that is, of course, an advantage compared to remote-controlled weapons, which require still communication between operator and the drone or the remote control system. And then also operating in greater numbers, including swarms, because, of course, not each of the systems needs to be operated by one person. And so you need fewer human resources for individual strikes. So these current trends in military interest and investment indicate that in the future, autonomous weapons will be increasingly reliant on artificial intelligence and machine learning software. They might be used to target a greater variety of objects or used to target people. They will probably be increasingly mobile or used over wider areas and for longer periods, carrying out multiple strikes. They are likely to be used in cities and towns where civilians are most at risk, and also used without effective human supervision and timely intervention. So here I'll also mention three particular risks and why, in the view of the ICRC, actually in this particular case, there is a requirement for a development of the law. The first is unpredictability. Now, there is always an inherent degree of unpredictability in the effects of using autonomous weapons because, as we said before, the user doesn't choose at the time of triggering the weapon or know the specific target and the precise timing or location of the resulting application of force. And so the trends that I was just mentioning will increase the unpredictability of these effects and therefore the risks of civilians. So again, the use against a wider range of targets, longer durations, wider areas, and specifically more dynamic and congested and complex environment. So in addition, the development of autonomous weapons controlled by artificial intelligence.
Cordula, if you can move to conclusion, it will be good. Sorry to bother.
Yeah, I'm in 3 minutes.
Okay, thank you.
So unpredictability, as I was saying, creates, of course, a problem about weapons which could be by their nature indiscriminate. So these would then, of course, already be prohibited by international humanitarian law because the user wouldn't be able to reasonably foresee the consequences. However, because of the lack of clarity of how states understand this rule, for us, it seems that new law would be warranted. The second problem is the targeting of persons. Now, that creates a risk from the legal perspective because whether a person can be lawfully targeted in an armed conflict is highly contextual, changes very rapidly in congested environment, and therefore doesn't lend itself very easily to a standardized target profile. Moreover, and perhaps more importantly, it creates extremely important ethical concerns for humanity because it is associated with the loss of human agency of the person triggering the weapon and moral responsibility because of the remoteness of the decision to use force, and also human dignity in life and death decisions. And it also, if you will, takes away the possibility for restraint, which is a human quality that means people can also decide not to use force, even if it would be lawful. And on the basis of that, from the point of view of the ICRC, anti-personnel autonomous weapon systems should be prohibited. Thirdly, and lastly, I think what we see is we have a number of autonomous weapon systems today that are very much limited in terms of time, space, and the type of area in which they are used. They are usually used against objects that are military by nature, so anti-missile defense systems are typical of that. they are usually not very mobile. They're usually, you know, for instance, to defend ships or to defend military compounds, etc. And as far at least as the ICRC knows, they are still supervised by a human who can intervene and suspend or stop the attack. And it seems to us that on the basis of the practice that we have today, we already get an indication of where the limits should be on autonomous weapon systems, both from an ethical perspective as well as from a legal perspective. So in that sense, it seems to us that for autonomous weapon systems, not all the answers can be found in international humanitarian law, first because of the clarity or lack thereof, and secondly also because of ethical concerns that aren't readily, that don't readily find an answer in IHL as it is. So I leave it at that and thank you.
Thank you very much, Cordula. Yahli, the floor is yours.
Okay, I'll do my best to be a bit below 50 minutes. Hope that it will work. Okay, so I'm very happy to be here today despite the awful situation. And this is the only panel during these 2 days that directly discusses issues relating to armed conflicts. And it's a good reminder that we are dealing with issues of life and death when we're talking about these issues, and I will return to this point later. I'm here focusing on something a bit different than autonomous weapons, on enhanced soldiers, but more broadly on new technologies in warfare. So, sorry. So I've recently published an article on the equal application of international law to enhanced soldiers. The definition of enhanced soldiers and human enhancement more generally is the subject of much debate. And while this is a highly interesting debate, for this short presentation, I really rely on an imperfect definition of enhanced soldiers as soldiers that undergo procedures to improve their capabilities besides what is necessary to achieve, sustain, or restore health. There's a wide spectrum, as you can see here on the slide, of potential military human enhancement technologies that range from pharmaceutical enhancement to the cybernetic enhancement of soldiers' brain. And equally, there's a wide spectrum of enhanced capabilities that include, inter alia, increases to a soldier's strength, cognition, and endurance. It's expected that rather soon, enhanced soldiers will become an integral part of militaries around the world. And my paper focuses on the question of the equal application of international humanitarian law and international human rights law to regular and enhanced soldiers. Think, for example, of an enhanced soldier that feels significantly less pain than a regular soldier. Should the threshold of what amounts to torture or inhumane treatment be the same for such soldier as it is for regular soldier? While some scholars seem to adopt such a position, the paper takes a different approach. It argues for a one-directional approach, according to which differences between soldiers could be used to improve the protection of those who are more vulnerable, but cannot justify harsher treatment of enhanced soldiers with superior capabilities. I hope that those of you who find this question interesting will take the time to read the full paper where I try to defend this position. In this presentation, however, I would like to focus on some broader issues. And as is often the case, I've been workshopping the paper in different forums to receive feedback. And I benefited tremendously from the discussion of my paper in these meetings. And much of the discussion naturally focused on the main argument of the paper that, as I said, I'm not addressing here. However, I found that I was repeatedly asked questions that are relevant to the study of law, war, and technology beyond this specific project. And here I want to focus on some of these questions. Law and technology is strongly oriented to the future. This makes the study of law and technology so exciting, right? But it also carries costs. One potential cost is the tendency to focus on transformative changes rather than on smaller, more incremental changes. I begin my paper with a non-orthodox example from the late 19th century, but acknowledge the vast use of sci-fi and fantasy in academic writing on law and technology. Later in the paper, I also use such an example from X-Men, who we all love, to demonstrate one of my arguments. These examples follow the popular imagination of future technological changes. They often include a radical change in reality. When most people hear the term enhanced soldiers, and I can tell you this because I talked with many people on this subject, they imagine RoboCop, Wolverine, the $6 Million Man, or Captain America. And as a result, I was often asked questions about the legal personality of enhanced soldiers and on the human post-human divide. At what point I was asked on the spectrum of enhancement, should an enhanced soldier be classified in a different category with significant legal implications? This is clearly an interesting discussion that is an inevitable part of the ethical and legal debates about enhanced soldiers. Nonetheless, there is a danger that focusing on this end of the spectrum yields insufficient attention to more limited but immediate technological advancements. The near future of enhanced soldiers will not introduce RoboCop type soldiers into the battlefield like we see here in the presentation, but it will likely feature soldiers whose capabilities are improved in less radical ways. And there's much benefit in focusing on the near future in the scholarly work that aims to change the regulation of new technologies. A good example of a similar phenomenon that actually addresses our last presentation is found in discussions about artificial intelligence in the military context. The vast majority of these discussions focused on the potential integration of autonomous weapons in the military. A quick Google search demonstrates the enormous interest in the subject. And although interest in autonomous weapons is justified and there are increasing signs that we are closer to their use on the battlefield, other important applications of AI in the military have received much less attention despite their significant implications and their imminence. It's only recently that scholars like Dustin, who will talk after me, have begun to look beyond the question of autonomous weapons to explore a wider area of questions regarding AI applications in the military context. Of more relevance to enhanced soldiers, we see that focusing on transformative changes emphasizes otherness. Otherness is a well-known concern in international law, and particularly in IHL. It enables harsher treatment of those who are considered as the other. It is important to focus on the humanity of enhanced soldiers when discussing the legal rules that apply to them in order to take full account of their interest in relevant normative discussions. The humanity of enhanced soldiers brings me to the second part of this short presentation. A second question that I was often asked when presenting the paper focused on the unequal effects of enhanced soldiers on parties to a conflict. Enhanced soldiers benefit powerful states, and therefore, so the argument goes, IHL should provide negative incentives for their use, including perhaps harsher treatment of enhanced soldiers. The distributional effect of new technologies in warfare is an important and challenging issue that is much broader than the narrow issue of enhanced soldiers or even technology in war more generally. It emphasizes the rather limited aspiration of IHL to mitigate suffering in warfare without intervening in the power differences between the parties to the conflict. It reinforces the limitations of IHL and the necessity of looking beyond IHL sometimes. The importance of jus ad bellum. We see it clearly during the past week. The power differences between the parties to the conflict also explain why it is so difficult to create new formal rules regarding contemporary challenges to IHL, such as asymmetric conflicts, cyber, autonomous weapons, and enhanced soldiers. and why different actors use informal ways to shape the law, as we just saw yesterday with the new ICRC position on autonomous weapons. Here, however, I want to take this important challenge and focus on two aspects that those who raised this challenge that I've just mentioned regarding the power differences do not fully consider. IHL's starting point is an armed conflict, a reality that almost always entails enormous suffering. It's based on the acceptance to some extent of this reality of violence, while focusing on its mitigation. There's a danger that such acceptance will legitimize violence, especially when it is aimed at legitimate targets. Nazmud Irzadeh published an important paper that was much discussed on passion in IHL scholarship. It suggests that the current literature on IHL lacks passion, that it is too technical, doctrinal, and distant. I want to address here a related aspect of passion in IHL. The importance of fighting the internalization of the legitimizing aspects of IHL. To experience the humanity of soldiers and enhanced soldiers, even when they're legitimate targets. When considering normative questions in IHL, I often remind myself how I felt when I first read All Quiet on the Western Front, or the descriptions of the experiences of individual soldiers in just and unjust wars. The existence of an individual beyond the highly important, broad, political, moral, and legal questions must remain at the forefront of our thinking. In contrast to other emerging technologies that are discussed here today, the human is an integral part of the enhanced soldier. Any discussion of negative and positive incentives in this regard must consider the interest of the enhanced soldiers themselves. The second issue relates to the peril and promise of emerging technologies. The discussion of emerging technologies in war often focuses on the potential adverse effect of these technologies on the other party to the conflict, as again, we saw during the first presentation. I also find myself often focusing on these concerns when thinking of new technologies such as autonomous weapons, enhanced soldiers, cyber warfare, and drones. I believe that there are two aspects that contribute to the focus on the perils of new technologies. The first is the deep distrust in states' behavior and the fear that they will use powerful new technologies to significantly increase suffering in warfare. For example, there is a danger that the added protection that new technologies provide to soldiers reduces the burden of using force and incentivize states and potentially other actors to use force more often. The second is some version of technophobia that increases the weight of potential adverse effect of technology. While the first concern is justified and should be addressed in any discussion of new technologies in warfare, the second concern should be overcome in these discussions. It's important to explore in any discussion of new technologies in warfare its potential to mitigate suffering in warfare as well. For example, the existence of precision-guided munitions has the potential to reduce the number of civilian casualties in warfare, including a potential obligation to use such weapons in certain circumstances. Soldiers are prone to mistakes. We cannot forget it, right? The high number of casualties from friendly fire demonstrate this point. Enhanced soldiers might mitigate some of the deficiencies of regular soldiers and have the potential to reduce unnecessary suffering in warfare. Such a promise should be taken into account when discussing the effect of new technologies on power differences in war and more generally, and this applies clearly also to autonomous weapons. The million-dollar question is how to find a proper balance between the promise and perils of new technologies, and I can say I have no magic solution. There is no easy answer to this question, but the path should include an attempt to take all relevant considerations into account while differentiating between justified concerns and unsubstantiated fears. Thanks, I'm really looking forward for the discussion.
Thank you, Yahli. Is it your handwriting?
I have an awful handwriting.
Thank you very much. This was yet another fascinating, very insightful and thought-provoking presentation. And we now move to our first speaker. Dustin, the floor is yours.
Excellent. Thanks very much. And just confirm you can see my presentation. Perfect. Thank you. So I'd like to thank the Federman Cybersecurity Research Center and the Cyber Law and Policy Center for inviting me to take part in the panel. A quick note at the outset on framing. So sometimes when discussing these issues, the conversation can feel overly abstract and convoluted, partly because they're trying to engage two very technical, esoteric fields with international law on one hand and artificial intelligence on the other. But what might it first appear to be quite abstract, of course, ultimately, as Cordula and Yahli noted, entails extraordinary consequences for the lives of the people affected by armed conflict. So while I'll be focusing on these aspects primarily from a doctrinal perspective, as their presentations, and I hope mine also underscore, these stakes are quite high, as no doubt all of us today can recognize. So to summarize what I'm going to try to cover, and I'll try to do so really quickly, is three main aspects. So the first point is that the wider and more diverse applications of algorithmic and data-reliant socio-technical systems in armed conflicts span not only fighting and weapons, but also several other issues that can arise in wars, including things like detention, humanitarian services, maritime systems, and even legal advice itself. Second point that I want to emphasize, and that'll structure part of my presentation, is that at least from my perspective, when we try to look at the systemic concerns for respect for the law, a key issue concerns whether international law will develop in the coming years to ensure that human agents, not artificial agents, but human agents, can and must be responsible for sufficiently foreseeing, understanding, administering, and tracing the activities and decisions involved in the use of these systems. And the third point, which is one I'll go very quickly over, is there's various pathways that international actors, primarily states, can take to help secure greater respect for international law in this area. First is to form and express positions on key legal issues. Second would be to take measures relative to their own conduct. And a third would be to take steps concerning the conduct of others. And I'll try to highlight why some of these systems might pose new or at least slightly different challenges than with respect to other types of technology. So by way of quick background, the project that we recently concluded the research for was a multi-year initiative where we sought to identify the views of states and to anticipate what might be some concerns on the horizon as more and more of these systems are employed in relation to armed conflicts. And includes a 200-page compilation of states' views on international legal aspects and a legal commentary, which I'm going to be drawing on heavily for today. At the outset, I think there's a very basic question about what are we really talking about here. Cordula mentioned cyber and autonomous weapons. Yahli mentioned some of the technologies underlying enhancement for soldiers and the diverse range of those. At the UNGGE on lethal emerging technologies in the area of lethal autonomous weapon systems, there's no agreement yet on exactly what the definitional contours are. So is it AI, automation, autonomy, cyber, digitalization, computation? All of these aspects come into view, but I have yet to find like a sort of a framework that really addresses these suite of technical applications in a holistic manner. The shorthand that we've come up with so far, which is ultimately not fully availing, I would say, is that there's focusing from an analytical, descriptive, and normative perspective. There's some value in focusing on a conceptual notion of algorithmic and data-reliant socio-technical systems in armed conflicts. Algorithms and data, in part because they're some of the key ingredients to this question of delegating to technical systems and away from humans some of the decisions and conduct pertaining to armed conflicts. And then foregrounding by mentioning socio-technical systems, the role of the one or more humans in the development and use of the systems rather than isolating the technical components on their own. So instead of focusing solely on the system, on the technical element, trying to integrate that into a sense that these are socio-technical systems that involve always some sort of interaction. And drawing on one of yesterday's panels, this idea of a hyper nudge in the form of AI, I think is very important to consider, not only in the regulatory context from yesterday, but also armed conflict more broadly. So here we see in our research that there's an increased reliance, at least among technologically advanced militaries and governments, to rely on these systems to kill combatants, destroy enemy installations, but also to detain adversaries, protect civilians, to undertake missions at sea, provide legal advice, and even configure war-related logistics. There are a few, I think, functional and thematic areas that will be untouched by these systems ultimately. I won't go through the examples, but you can find these in the literature. They concern things like using supervised machine learning as an aspect potentially of a targeting process, or even unsupervised machine learning for elements of trying to identify whom to subject to deprivation of liberty in order to thwart an attack. Instead, I'll move back to what I consider to be this key question from a systemic perspective for the capacity of international law to meaningfully govern armed conflicts. And so again, that question, the way I see it, is will international law develop in the coming years so as to ensure that human agents can and must be responsible for sufficiently foreseeing, understanding, administering, and tracing activities and decisions involved in the use of algorithmic and data-reliant socio-technical systems in armed conflicts. So embedded in this question, I think there's at least four aspects. One concerns who or what, humans or artificial agents or some combination, will be responsible from a legal perspective, including for exercising legal rights and obligations under applicable legal fields, including IHL. Second would be what it means sufficiently to predict the effects, behaviors, and performance of these systems, whether in the conduct of hostilities, in deprivation of liberty operations, and humanitarian services, in their particular environments of use. What, as a third aspect, what the law demands in terms of ongoing oversight, supervision, and intervention during the use of these systems. And what it means to be able to reconstruct, as a fourth aspect, after the fact, how the system behaved and what the various computational components involved were, in order to make a legal assessment, and if a violation may have occurred, to impose responsibility if the violation was sustained. There's various aspects, various measures I mentioned that states and other international actors may take to help secure greater respect for the law in this area. I think that with the use of these socio-technical systems that are reliant on war algorithms and data, that there's enhanced, it'd be prudential for states, especially to try to institute various things like education and training, making sure that everybody who's involved in ensuring respect for the law, not only individual soldiers or commanders, but even judges and prosecutors, et cetera, are sufficiently apprised of the aspects of these, and that this would entail a very long-term commitment to securing respect in a systemic way. The key issue, though, that I think really is at the core of the debate right now concerns whether or not international actors, including states, ought to pledge to engage and to call upon others to engage only in armed conflict-related conducts that is sufficiently attributable, discernible, and scrutable. So in terms of the three specific pathways, and I'll focus on the first one and then blaze through the last two. The first one concerns forming and publicly expressing positions on the legal questions. So I'll highlight three here that I think warrant particular attention concerning artificial intelligence in particular. One is whether, as a legal matter, armed conflict-related conduct ought to be reflective of human agency, and if so, what that means. Does it mean, for example, that the conduct is subject to the exercise by one or more natural persons of intent, knowledge, and causal control in relation to the conduct? Second question concerns whether the legally mandated evaluative decisions in normative or value judgments may be reposed only in natural persons, or if in some sense they might be reposed in a combination of natural persons and artificial agents, or even potentially at the far end of the extreme in artificial persons. So think here in terms of the IHL or LOAC provisions concerning what constitutes, situation for imperatively demanded by the necessities of war for destruction or seizure of enemy property, what the excessive dimension the value judgment entails for the IHL LOAC principle concerning proportionality in attacks, and what it even means to refrain from any act of hostility in trying to discern whether or not somebody is wounded and sick in legal terms. And then as a last question here, and the one that I highlighted earlier is, and I think this is really the core and a very difficult one, I think, from a political perspective, because states don't want to subject their armed conflicts related conduct to external scrutiny and sometimes even to internal scrutiny, is whether or not, as a legal matter, we ought to consider in pledging to engage only in conduct that is at least capable of facilitating attribution, discernibility, and scrutiny of the conduct of that system. Because if we don't, I think it's very difficult to make an assessment that the preconditions for the legal framework to actually constitute law in a meaningful sense can be said to exist. Second pathway concerns taking measures relative to the conduct of others. I won't go into these in detail, but I would just say that there's already several measures that states must undertake in order to secure respect for the law by their own soldiers and by others. And I think states haven't begun to grapple at great depth and urgency with what it'll take to be able to do things like prosecute alleged perpetrators of grave breaches or make legal advisors available to the armed forces when it comes to the diverse range of applications of this suite of technologies. And the last one, pathway concerns taking measures relative to the conduct of others. So here, I think there's a real concern about whether or not a state will be able to discern if another state or a non-state actor has respected the law by being able to attribute, discern, and scrutinize the conduct of that system's functioning employed by that other system. So how, for example, could you discharge your obligation to resort to penal measures against alleged grave breaches by a potential adversary or by another actor, if you, as the state itself, are not in a position to be able to attribute, discern, and scrutinize that conduct? So again, just to summarize, start to end where I began, I think it's very important to consider the life and death stakes of these technologies, not only in relation to fighting and weapons, but also into provision of humanitarian services, detention, and other areas of armed conflict. And that whether or not human agents are going to be responsible for sufficiently foreseeing, understanding, administering, and tracing these activities and decisions is an area that, to my mind, is very important to frame the core questions around what it means to respect the law when it comes to these AI and other applications.
Thank you very much, Dustin. The floor is now open for Q&A. If anyone wishes to make a comment or raise any question. While we wait, if any of the speakers wishes to refer to one of the other presentations, you are more than welcome to do so. Yahli, Cordula.
Yeah, I have a question for Dustin, and you regarding your pathway that involves the engagement of different actors with the law. You look at it as a way to secure more greater role for international law, but you assume that the development will be beneficial, will promote the normative position that you think or is justified or that most of us think. But we all know that when you give actors that have strong interests regarding these issues the power to regulate, I'm not sure that we will like the result.
Yeah, thank you, Dustin. If it's okay, we have 2 more questions, so if you can collect them.
Great.
Thank you. So Amnon, please, and then Gadi.
Following up on Yahli's steps, I think what is perhaps slightly missing is the perspective that looks at it from the technological point of view. So there is a technological logic here. It's not just that technology evolves because it so happened to evolve. There are forces, technological and economic, and of course, military forces behind this. And then the question is, and so far the discussion assumed the separation between law and technology. Now, key to any serious discussion of law and technology is the question of what do we want to install by design? What type of features do we want because we can want, to the extent that we can have control over the evolution of technology at all, but to the extent that our agency and our legal capacity are such that can affect the evolution of technology, what would you like to see built into the technology itself? And then, that may change some of the pathways for development and things that were discussed by the three panelists.
Thank you very much, Amnon. We will hear Gadi's question, and then one last question by Yuval Shany, and then we will allow Dustin and any other speaker to answer or make a reference. Please, Gadi.
Well, I guess I'm a more tech geek, so my question is general. I would ask, I think, Cordula, and at first I would love to hear your opinion. It seems that there is a suspicion against technology in the basis of most of what you are talking about. And I don't know if I'm a romanticist of artificial intelligence, but I would think that I investigate crimes of war in the Israeli army. So I would give it, you won't see them tired, angry. They won't be vindictive. They have the potential for accuracy and to fulfill orders, which will never be possible by a human soldier. So I understand the risks, but I would ask, why is there so much suspicion for something that has an equal potential for good, for minimizing harm in the situation of war, which is the basics of IHL? So I would guess that's my question.
Thank you very much, Gadi. Yuval and Dafna also wants to join the discussion. So after Yuval, Dafna, please.
Yes, thank you. Very interesting presentations. I want to go back to issues of meaningful human control or agency that were raised, I think, in all three presentations. And I mean, knowing what we know about what is now called subliminal effect of technology on free will, I'm wondering to what extent are we, the horses have not already left the stable, in the sense that, I mean, human discretion is often constrained by technology to portray a situation where human will actually masters technology. I mean, it may be true at some very preliminary level of developing the technology, but once it's already in and around the battlefield, I'm wondering how much space is really left for what we call, maybe euphemistically, a meaningful human control.
Thank you, Yuval. Dafna, please.
Yeah, thank you all for a very interesting talk. My question is more general for all the panelists. I mean, when we think about technological process, but by definition, it entails novel concepts and new phenomena, and we all acknowledge, or we know that the huge gap in the context in which IGL, the legal framework of IGL was created, and the current and current reality. So even if we accept the approach of a living instrument, I mean, to what extent do you think that it's still sufficient, or at what point we can say that the interpretation, the concept of interpretation from existing norms is maybe a kind of a mistake. I mean, you've mentioned data as objects, and Yahli, you've mentioned it on your talk on enhanced soldiers. So I'm kind of I am curious to hear your thoughts about it. Thank you.
Thank you, Dafna. Maybe you can hear now from the speakers in the reverse order. So Dustin, Yahli, and Cordula.
Great, thanks. So I'll try to cover a few really quickly. So Yahli's question, absolutely. I think this is a key question of how much do you actually want to invite international actors to address things expressly. But to my mind, international law is foundationally based on states' participation in their national system, and we really want to know what they think so we can subject that to scrutiny. In the GG on autonomous weapons, there's 100 states that have submitted their views at various levels of technical proficiency, and we can find that, for instance, the US and Russia actually have a whole lot more in common on their views of some of what legal compliance entails and what the potential for the technologies are. And also subject, for instance, China's views on their definition of autonomous weapons to scrutiny, which to my mind, their definition already entails an inherently indiscriminate weapon, which you would think would already be unlawful. So absolutely, point taken, but I think this is the way that the system is built in terms of its preconditions. And Amnon's point, I think the issue that came up yesterday around code is law and the sort of normativity baked into the system is a really important one. And I think this is a design aspect, but I think also there's questions as to what it means ultimately to hold a single person responsible for compliance. And this is an issue that's front and center right now in the context of autonomous weapons, especially within the targeting cycle. So is there one person, the commander, for instance, can that person rely on maybe a dozen or hundreds of people's activities and decisions that have led to the point of deciding whether or not to launch an attack? How much does that one person need to know in terms of the normativities that have been baked into the system at the various different stages of the development and use and the incorporation of the data and whatnot? I think it's an open question, and international law is not very good at it right now. And I think we should start thinking much more about how to bake in the elements of normativity. And I'll leave it there. Yeah.
Thank you, Dustin. Yahli, please.
Yeah, thanks. I'll try to be quick as well. To what Daphna asked, I think that you should always ask yourself, what's the alternative, right? If there's zero prospect of creating new formal rules, then what's your alternative? To have a legal black hole, right? So unfortunately,
to create new frameworks more relevant for.
Who will create it? Who's the relevant actor? What's the capacity? So I don't think that there is a void, right? So other actors use informal ways in order to advance the law. They call it interpretation because it's the only tool available. But no one really thinks, for example, that the customary IHL study is only the identification of customary norms. No one thinks that right? That the new commentaries on the Geneva Convention, sorry, Cordula, that it's like pure interpretation and nothing creative. This is the tools that you have, and this is the way to promote the law when there's no prospect of creating new formal sources that will address it properly. And to what Dustin just said, is that I think that there's something symbolic but really important about this notion of control, right? So even if in fact we do not have free will, or even if we're subjected to so many factors that force us to decide in one way or another, the symbol of control is something extremely important in this area of law. And I think that this fiction should be maintained as much as possible.
Thank you, Yahli. Cordula?
Yes, thank you. So perhaps a few questions. One is this question around the suspicion against technology. And I think you have to, in a way, the law should be technology agnostic, as in all technology, whatever it is, should abide by the law. But of course, new technologies evolve and the law might not have all the answers, particularly when there is such a profound change in the way technologies will affect the way we work. And I know Yahli said we also have to concentrate on the smaller changes. And I think that's very, very true. But I also think this digital revolution will affect all of the ways of our lives, you know, from our private lives to business to war. And that poses, I think we are at a moment where we have to ask ourselves very fundamental ethical questions about these new technologies. And so the question is really from our perspective, and perhaps I think, I don't know if I understood you correctly, Yahli, but I think it perhaps relates a little bit to what you said about the importance of the symbolism of control. And I would say the point here is that technology should be made to help human judgment, but it should not replace human judgment. And perhaps similarly, although I'm not sure that's what you meant, Yahli, but let's say we were going down the path of enhanced soldiers, then again, perhaps the enhancement should, you know, be at the service of the soldier, but without taking away the humanity of the soldier. And again, I think this raises very fundamental ethical questions, which are of course to do with human enhancement before we even talk about soldiers' enhancement. But so, you know, there is a lot of talk also among states about a human-centric approach to new technologies. And I think there is very much something to that. We need to define more clearly what it is, but it seems to me that human agency and human dignity is what, you know, in a way preserves a measure of humanity in everything that we're doing, and that this is what we're trying to find in the balance between what technologies do we want to support and which technologies do we want to restrain. And I think it has always been thus. So when you think, for instance, about biotechnologies, that, you know, when the biological weapons conventions was, you know, called for, it was very much called for by scientists, because scientists were under pressure, because of course what they were doing could have good effects or very dangerous effects. And many scientists were saying, we would like a clear framework to say what is acceptable and what isn't. And the biological weapons conventions has prohibited biological weapons, but it hasn't prevented biological research and progress. And so I think it is not about being skeptical or phobic of technologies. It's about setting the framework of what is it in technologies that we want to do because we agree with it and think it is good, and what is it that we think is not good and beyond the pale, to put it very simply. And for me, it's about not replacing human judgment. So for instance, artificial intelligence can very much enhance human judgment, but it should be at the service of human judgment, not replace it. And I think, Yuval, you were asking, well, haven't we left the stable? And I think that is a concern. And in terms of artificial intelligence and machine learning, what we hear very much is, well, this will allow for the processing, of course, of vast amount of data at much greater speed, etc. But it will, I think, eventually pose the question about, well, so what is left really for the commander or the user of a weapon or the decision maker in a situation of fighting or armed conflict, or as Dustin was saying, detention or other, will there still even be any human judgment left? And I think there again, it will be very important to set the parameters of that out and not let it happen. And I do not think that the horses have left the stable. And why is that? Is because when you look, for instance, at autonomous weapons systems that are being tried out, that exists, you can see that not all of them have been deployed. Not everything that is possible technologically today has been used on the battlefield. Much more than what is possible, than what has been used on the battlefield would be possible. But belligerents haven't chosen to use what is available today, because somehow there's a decision that some of it is not acceptable. And of course, you might say, well, when the technology develops, some more of it will be acceptable. But there will always be a choice, I think, for states to decide what is acceptable on the battlefield or not. And then the last question was about, well, do we still rely on these existing norms, or is it a mistake? And I think the answer to that is it's both, in the sense that, I mean, existing law, IHL, but of course human rights law as well, and Yahli was talking about jus ad bellum, there is very dense existing international law, and it regulates much of what we are talking about and restrains much of the behavior of belligerents. So of course we need to rely on it. And I think we would throw it out at our peril. But I also think, as I said before, it doesn't have all the answers. And so we have to ask ourselves, deeper and more moral questions about what it is that how we want wars to look like. Thank you.
Thank you very much, Cordula. Thank you very much to the three speakers and the participants in the Q&A. And without further ado, I will yield the floor to Professor Yuval Shany, the director of the law program of the Federman Cybersecurity Research Center. So we will move to the next panel.
Okay, thank you, Tal, and thank all the speakers and participants in the previous session. And so we have arrived at the fourth and last panel of this conference. So we are talking in this conference about questions relating to regulation of quasi-sovereign powers in face of new technological and cyber developments. Yesterday, we talked about the regulatory questions that arise from the perspective of states and businesses. To the extent, what extent do states regulate businesses? What extent do businesses regulate states? And today we were now just talking about one particular form of regulation, which is an international law-based framework for regulating technology. And the final issue or the final aspect we would wish to cover is whether the technology in itself is a form of regulation and whether it can be understood as a form of governance. And for this last panel, we have a very impressive set of three speakers. I will introduce them very briefly in the interest of time, and then we will hear presentations and hopefully have some time also for Q&A. The first speaker would be Dr. Tomer Shadmy, who many of you in Israel know. Tomer is a research fellow at the Federman Cyber Security Center in Jerusalem, also works for the INSS, the Institute for National Security Studies, and she specializes in the legal, ethical, social, and political challenges associated with governance of new technologies, new and emerging technologies, such as AI, both governance of AI and also governance by AI. The second speaker would be Professor Katrina Ligett, also from Hebrew University of Jerusalem, from the Federman, from the Federman Cybersecurity Research Center, and also for the Federman Center for the Study of Rationality. Where is Katrina? I think I saw her before. I'm wondering whether there's a third Federman Institute with which she is affiliated with.
I'll try to collect some more. I'll work on that.
but Katrina is also affiliated with the California Institute of Technology, and she's a computer scientist, and her appointment is with the School of Computer Science, where she works on privacy and algorithmic game theory, and among many other things that she does, she works on the interplay between users and platforms in shaping online policy. And the third and final speaker, last but not least, would be Professor Roger Brownsword from King's College School of Law in London. And he's the founding and general editor of Law, Innovation and Technology, and works on a vast range of issues, including law and bioethics and regulation of technology. So without further ado, I pass the floor to you, Tomer, to start. Try to keep it within 15 minutes tops, each of you. Thank you.
Okay, thank you. I just, I need to share my screen. Can you make me co-host, please?
I do not have such a power, but maybe Tal has.
Tal, can you do it, please? Okay.
You're a co-host.
Great. Okay. So I will present today a paper that is now in its final draft stage. So I would be very happy to hear your comment. And I would also ask you not to use the ideas and framing in the meantime until the paper will be ready and submitted in the summer. But before I will begin, I must point out how hard it's for me to continue here and pretending that everything is normal while everything is not normal and not fine. And my country is burning and my heart is burning and human beings are burning. I found this full comic by Casey Green. By Casey Green, from which the famous meme is taken, you know, in the upstairs. I think it's expressed more than many other things, the spirit of our age. I want to frame my talk today using this meme and in order to ask what is the role of social media in maintaining these frames that surround us, and how can social media regulation reduce these flames? So before I start with disinformation, it is important me to bring up another phenomenon, which at this point I have nothing smart to say, but in what is happening right now in Israel, it plays a major role, and also in the Capitol Hall in January. So it's like organizing act of violence using apps like Telegram and WhatsApp. So as I said, I have so far nothing wise to say about it, perhaps at the next conference next year, but I would like to point out the importance of engaging in this field. So the problem that I do want to talk about is the spread of disinformation through social media. Here you can see, for example, false news item that was circulated yesterday on social network in Israel in an effort to increase the flames. So what can we do against it? So the problem I do want, what I'm proposing is to make use of substantive regulation of AI in dealing with the problem created by regulation by AI. I will argue that much of the impact of disinformation is created not because of the content itself, but because of its mode of distribution, which is managed by AI. Therefore, dealing with the phenomenon requires intervention in this system of AI. For this, the procedural regulation of AI that we can see in the new draft of the EU, for example, is not enough. But we need specific and substantial regulation in this field. So in the public discourse, as well in the legal discourse, the problem of disinformation is framed as a problem involving the content itself, and therefore the solution to it lies in content moderation, as we heard yesterday. Whether if it's done through state law, and even if it's done through platforms law and a body that the platform appoints. This approach, when dealing with disinformation, lead to a dead end, because it requires that some bodies will be the arbiters of truth, whether it is a state agency, a corporation, or civic body. Each of these options is problematic in a democracy, what leads us to more and more fire and flames. I argue that both the problem and the solution do not lie in the content itself, but in the way in which it is distributed. To whom is it distributed, why, and at what intensity. Imagine a road with a lot of twists and turns created to allow exposure to ads. Such a structure of road could cause endless road accidents. The way to prevent such accidents is not to put countless policemen on the road, or body that will supervise the policemen, all of which will not prevent accidents. The way to prevent accidents is to change the route of the road. The twisted mode of distribution of content in social media is this road, and regulation should impose restriction on the structure of the road, not just on its drivers. There are many studies in the field of media studies and parallel field that indicate that the business model of social media based on ad micro-targeting leads to preferences to extreme content, produce filter bubbles and echo chambers, and create content clusters such as conspiracy-based content distributed in a similar manner to similar audiences. All of this together make a crucial contribution to the impact of disinformation and to the difficulty of holding a joint public debate based on a shared perception of reality. So if I'm right, and the large part of the impact of disinformation is caused by the way in which AI system controls the distribution of content, then regulation of this way can help to deal with the phenomenon. So how regulation of AI could mitigate the regulation by AI harms? We have now the EU draft of AI Act. Can it help in this mission? Unfortunately, perhaps no. The obligation highlighted in this regulation are procedural, not substantial obligation. They are also general and not specific obligation for a particular field. They state, for example, that data should be relevant, diverse, and documented, but this provision, even if they will apply to social media, and most likely they will not, do not provide tools for dealing with the problem I described earlier. So what else can we do? We need a specific regulation for specific areas that will address specific risk and impose specific substantial restriction on various stages of the life cycle of AI systems. One option for intervention, which I detail in the paper itself, is putting restriction on the amount of use of prediction, which mean in this case, limiting the amount of engagement-based recommendation or correlative metrics. Just as the level of nicotine in cigarette is limited, so here the intention is that there will be limited level of content that AI system will expose to user based on the metric of engagement. For example, on YouTube, in viewing recommendation, there will be, for example, 2 recommendations based on such metrics, and the rest of the recommendation will be completely random. Such an intervention can reduce the exposure to extreme content, as well to reduce the effect of filter bubble and echo chambers. Another option for intervention is putting restriction on the system objective and measurement, which mean in this case, restriction certain modes of personalization. This means restriction on the decision which content will be presented to whom and on what basis. This option does not prohibit personalization as such, but does restrict it. Again, I do not have the time here to go into details, which are also needed a lot of future research, but this is a kind of intervention which I think can help here. So in summary, the type of regulation I have proposed has some major advantage. Firstly, it deals with the phenomenon of disinformation without infringing on the freedom of expression of end users. Second, it can create a healthier discourse environment. Remember the road. So this regulation reduces some of the twists and turns of the content highway, enhance some of its risk. Thirdly, this regulation does not require appointment of arbiters of truth who will decide what is true and what is false for others. The regulation, yes, can harm what is particularly framed in the US as the First Amendment right of platforms themselves. And it is also possess a huge enforcement challenges. However, I believe that these are challenges that must be addressed in order to lower the flames which at the moment threaten to harm us and our democracies. Thank you.
Thank you very much, Tomer. We now move to Katrina. Katrina, you have the floor.
Great, thank you. So I'm going to build in some ways on some of the ideas that Tomer raised in her talk. Thank you, Tomer. I'll just mention, as Tomer did, that some of the ideas I'll be talking about are things that I am writing about and thinking about with Tomer, with other folks who I'm working with through our data cooperatives research group, including Ayelet Gordon, Colby Nissim. And so as Tomer said, please get in touch if you're interested in building on any of these ideas. So I'll start from the question that Yuval framed at the beginning of the session. Is technology a form of governance? Certainly, absolutely. We see that, as Tomer alluded to, technologies and tech companies are deciding in today's world which voices are heard and which voices are silenced. They're deciding, in some sense, who actually has value and who has money. Smart contracts are deciding, in some sense, and cryptocurrencies are helping us decide what is reality and what will reality be. So we see all sorts of forms of technology as a form of governance. What I'd like to argue today is that some of the regulation of technology, I think, must be done by technology. And so there is really a role for technology as a form of governance of technology. So I'll try to get there. So to start with, though, maybe I'll look a little bit and share a little bit of my perspective on some of the main ways in which we have tried to regulate technology, and in particular with a focus on sort of data-related concerns thus far. Because I think understanding some of the drawbacks of some of the approaches that we've taken historically to regulating can help us understand why we might need some new tools as we move forward. And I should say, actually, if it wasn't clear from Yuval's introduction, I'm a computer scientist. I am not a law scholar. I'm not an expert in regulation. Feel free to correct and inform me where you think I need to be corrected and informed on that side of things. So one thing that I see is really prevalent in our collective attempts to regulate, particularly data-related technologies, is an emphasis on individual choice and individual consent. This is a major theme that runs through a lot of regulation that I'm familiar with, where the framing is often, we need to give individuals choices about what's gathered. We need to make sure they're informed, they agree to whatever it is that they're about to be engaging in. And as long as we give individuals choices, privacy choices, choices to download their data, choices to opt out of various things, that maybe we can solve the problems, some of which Tomer alluded to. And I'm deeply critical, really, of this sort of individual consent and choice framing and approach for a number of reasons. Not that there's no role for individual choice or consent, but I think it's extremely problematic in a number of ways. One of them is that often the choices that we're exposing to individuals when we enable individual choice as a tool for regulating this space are the wrong choices or terrible choices. It's not enough to give someone a choice between you can use our system and suffer all the harms we choose to package with it, or you can opt out and lose the benefits when your system has become sort of a central communications tool. You know, there's some things that I really can't opt out of without having serious consequences in today's world. And as these digital technologies have become so central and so prominent in our lives, they serve more like, you know, utilities that we all need access to, and we ought to think of them in this way. It's not enough to say, oh, you know, you have the choice to opt out of having water in your house. That's not the right way to frame these things. So that's one concern with choice, but I think that's actually the fact that the choices are bad choices is really the tip of the iceberg. The second problem with individual choice is that framing the problem in this way implies that individuals are responsible. If you just have to make the right choices as an individual, and then everything will be fine. It pushes the responsibility onto the individuals in a way that I find in many contexts completely inappropriate. Even if the choices were reasonable choices, it is completely unreasonable to expect individuals to be tasked with making them, with understanding the consequences of them, of engaging with them continuously on a moment-by-moment basis. This is the wrong way to solve the problems. And then the third problem that I have with a sort of individual choice, consent kind of focus and framework in regulating in this space is that often it doesn't solve the problem. Many of the problems that we face with technology are simply not problems that can be solved at the level of the individual relationship with the provider, with the platform. And so I find this sort of framing and focus of a lot of the interventions problematic and sometimes sort of actually benefiting the platforms that we're trying to regulate, because it lets them offload an enormous amount of sort of responsibility at very, very little cost to them in many cases. Okay, so what do I think we need to do if we need to move away from this focus on sort of individual choice and consent? So one of the things that has become apparent to me in trying to focus in on some of the concerns that technology raises today, concerns like fairness, concerns like discrimination, manipulation, polarization, fake news, encroachment on personal autonomy, all of these types of damages that we potentially see from these systems, is that if you want to regulate and try to prevent, detect, limit a lot of these types of concerns, you can't do it at this individual level. You can't intervene at the level of the relationship between an individual and the platform. You need, in order to detect many of these problems and to do anything about them, you need a broader perspective in the system. And so I think it's going to be crucial that at least part of the solution is going to be some component that is going to have a broader perspective. To make this a little bit more crisp, maybe I'll point to the example of fairness. So you might be concerned that there's unfairness in, say, the provision of personalized advertising. And that might take the form, for example, of advertisements for higher paying jobs going to men and lower paying jobs going to women, for example, and it happens. How can we intervene on this problem? What can we do about it? Well, as Tomer pointed out, there are lots of places in the system where you could potentially intervene. But one thing you'll notice is that you can write a law to say that this is wrong and to say that, to try to prevent this problem at various points in the system. But if you actually want that law to be enforceable, you need to be able to detect in some way that this discrimination is happening. And if you want to be able to do that, you have to have some sort of collective viewpoint, because when I receive an advertisement, there's no way for me as an individual to know if that advertisement is discriminatory. I got the ad that I got. I didn't get some other ad, but I don't know about that other ad that I didn't get. And I certainly don't know how that ad was provided to me. I don't know the counterfactual. Had I been a slightly different person, would I still have received this ad? Had my behavior been slightly different, would I still have received this ad? And similarly, you as an individual can't know whether or not you're receiving something that's discriminatory. And in fact, discrimination is not even really meaningful. I can't even mathematically define what it is, and maybe you can't even legally or ethically define what it is without some point of comparison, without some counterfactual. If you only ever make one decision, what does it mean for it to be discriminatory? You have to view it in this broader context. And so I think it's really crucial that we think about interventions and regulation in these systems that have this collective perspective. And I would argue that this is a place where technology is really primely suited to regulate technology. And this is something that we're exploring deeply in this data cooperatives project, but I'll just mention briefly in one sentence that a major thread that we're exploring is ways to reshape the data ecosystem that involves specifically introducing an intermediating body that sits between individuals and those who use their data. And part of the idea there is that this body has the ability to have this collective perspective that you need, I think, in order to make a difference in a lot of the concerns that we see. So I'll stop there. Thank you.
Excellent, thank you. And thank you both, Tomer and Katrina, for sticking to time. And now the third speaker is Roger Brownsword. Roger, you have the floor.
Well, there we go. Thanks very much, Yuval. Thanks for the invitation to join the panel. I hope I'm speaking in a way that responds to the invitation you sent me, talking about the kind of things you want me to talk about. In 15 minutes, it's going to be very sketchy, but I understood you wanted me to talk about a bigger picture, and the components of the bigger picture are law, technology, and ethics. Those are the three components. And it's a bigger picture of what? Well, it's of governance. So what's the bigger picture of governance where the elements are law, ethics, technology? And I'm going to, the bigger picture has 3 sub-pictures within it, which I'll call the Law 1.0 picture, the Law 2.0 picture, and the Law 3.0 picture. These are the 3 sub-pictures within the big picture. Law 1.0 is the traditional law picture. You imagine there are lawyers, there are ethicists, there are technologists. They don't talk to one another. They don't have anything to share with one another. When I was an undergraduate, they used to say, you lawyers, you only ever talk to one another. You're always talking about law. You're sitting next to a technologist at a dinner party, it's not going to be much of a conversation. We don't have anything to say to the technologists. Oh, well, apologies to Katrina. Things are different these days. But, you know, once upon a time, we wouldn't have had anything to talk about, and that would have been the same for you too. You wouldn't have had anything to say to the lawyers, except for some compliance you have to take care of. But, okay, now the crucial thing here is that all communities, each community, law, ethics, and technology in this first part of the picture are very inward looking. They're doing their own thing. They're not worried about one another. They exist in splendid isolation. The lawyers, yeah, one of the first lessons for law students is, as Carl Llewellyn told the students at Columbia, put your ethics into a state of temporary anesthesia. That's what he said. Well, for some lawyers, it's a permanent state of anesthesia. We never get to have a conversation with ethics, except insofar as ethics is internalized already within legal. We don't have conversation with ethicists outside in this Law 1.0 picture. And the same's true of tech. You know, I mean, Judge Frank Easterbrook, nearly 25 years ago, one of the first cyber law conferences in Chicago. I mean, his famous put down there was, as you know, that, okay, you couple of hundred people here very enthusiastic about computing and that kind of thing, that's fine. But the idea that we should have a law of cyberspace, come on, you've got to be joking. You can't be serious. That's not how lawyers think. What lawyers do is, well, we apply these traditional legal principles in contracts and property and torts. We apply them to novel phenomena. Technology might be part of the phenomena, but we don't make a big deal of it. Warren and Brandeis, when they wrote their famous article in the Harvard Law Review in the 1890s, yeah, I mean, they were worried about the abuse of photography and cameras at that time. But, you know, they said, we don't need to trouble the legislature with this. We've got resources within the common law to deal with this. We can just apply these principles from tort land that will give us the kind of answer, the kind of protection we want. So the important thing here is that there's no interaction really between law, ethics, and technology in this first part of the picture. Okay, now moving on rapidly. Oh, I should say, 20 years ago, I was in Jerusalem physically at a conference where I was speaking about very early governance of e-commerce in one of the ministries. That was a textbook Law 1.0 conversation we were having there. How do the laws, the principles of contract law, how do their templates apply to these transactions, which are now going to be possible in some quite different kind of environment? Very much sort of Law 1.0, but we weren't talking to ethicists, and we were only talking to technologists, I think, insofar as we wanted to have slightly better understanding of what the kind of technology was. But anyway, so that's the first part of the picture. Now, the second part of the picture, the Law 2.0 picture, thinking like a lawyer now has become something rather different. It's become much more, as I would put it, regulatory, not about applying traditional principles. It's about thinking instrumentally about how law can serve specified regulatory policies. It's policy focused, not usually going on in the courts, at least not overtly, goes on in other parts of the legal empire, in government, in legislatures, in regulatory arenas. And now here, both ethics and technology are very definitely significant for lawyers. They're on the radar, okay? But they're on the radar in a way that's problematic. Lawyers speaking to ethicists is going to be a difficult conversation. Lawyers speaking to technologists, that's going to be a difficult conversation. But it's difficult all around. Technologists are worried about law. It's obstructive. You know, law and ethics too can get in the way of projects that technologists are very excited about. For everybody, wherever you're coming from in this second picture, it's a problem. You know, talking to these other people, but you can't ignore them because they have to be talked to. So let's just give you a couple of examples. Well, I first got interested in law and technology about 30 years ago when I went to a symposium at the European Patent Office, where the question was about the patentability of genetically engineered mouse, famous Onca mouse application, if you know it. And I mean, ethics was very visible outside the European Patent Office because there were a whole bunch of students from Max Planck there with placards saying no patents on life. And the whole thrust of this was it would be unethical to be encouraging through patents the research and development of genetically engineered products like this. They didn't like, it was unethical, okay? And the law had to take care of this, but you had to take that into account because as it happened, the European Patent Convention said that you could not grant patents on any inventions where it would be contrary toward public morality. So the ethicists couldn't be ignored. The same, I mean, of course, for the technologists, the idea that the Patent Office might not grant a patent on their research and development was hugely problematic because patents are crucial for raising finance for research and development. So you need to have the law on board with technological innovation. And I mean, another example of this would be, well, for 5 years, I chaired the Ethics and Governance Council for UK Biobank. Now, UK Biobank was a huge project, flagship project for the Wellcome Trust and the Medical Research Council, in which, to get the thing off the ground, 500,000 UK participants had to be recruited. And they tried a similar kind of thing in Iceland, which had gone badly wrong, because the public were brought properly on board with it. So UK Biobank set up an Ethics and Governance Council and articulated an ethics and governance framework, a kind of assurance to the British public that there wasn't going to be, as one participant put it, any kind of funny business going on in relation to all the data and biosamples that were going to be curated by UK Biobank. And what's going on here is an instrumental way of interacting with ethics, technologists here interacting in an instrumental way. It's about getting buy-in. In this case, as I say, the Biobank needed to ensure the trust and confidence of these many participants they were looking to recruit who were going to stay with the project. And the Ethics and Governance Framework and the Council were a kind of signal that they were going to try to do the right thing. But it wasn't ethics for its own sake. It was ethics in an instrumental way. And if you think about the tech companies who are now very busy with their own ethical activities, you can see there's a certain sort of instrumental thinking there too, that you want people to buy into Facebook or, to think that these are good people. Yeah. Okay, so there's a problem to be smoothed over in this part of the picture. Lawyers have to talk to ethicists, lawyers have to talk to tech, and all around the pack, everybody's talking to everybody, but it's a problematic conversation. It's not easy. Okay, that's the second part of it. And I'm picking up something that Cordula was saying earlier on about the problems of applying international humanitarian law to new technologies. Yeah, of course, when I'm saying that technology is problematic for law, it's not just problematic because you're trying to achieve acceptable accommodations of a whole range of interests, a plurality of interests. Tech is problematic because it comes on the scene in a way that catches out the previous laws that have been written for another generation. And making that initial connection is a problem, and maintaining the connection is a problem too, because technology is going to move on in ways that hard laws don't always anticipate. So there are problems about connection, about regulatory connection. Some technologies give rise to problems about regulatory effectiveness. The internet is an absolute classic. I mean, information technology where people can supply goods and services from outside jurisdiction. Well, this means that local regulators have huge problems in ensuring that they can do the things they want to do without being interfered with by suppliers coming from outside their territories. So that's problematic. But the point I've really been trying to raise is that it's also problematic too, as regulators are trying to achieve an acceptable accommodation of the interests of different stakeholders, of the innovators and research and development communities on the one hand, and the publics who are worried about, well, consumer safety, you know, whatever it might be, environment, all sorts of concerns here, pushback against these new technologies that the regulators have to deal with. And I should say that at that conference in Jerusalem 20 years ago, we were also talking about e-money, but the conversation there was not Law 1.0, it was Law 2.0. It was about how do the regulatory frameworks that we already have for these financial markets operate when you have something like e-money coming into play. And of course, you see those debates now in capital letters all over the place as regulators worry about what to do about cryptocurrencies that are popping up, you know, all over the world. So there are regulatory questions there. But the important point is that in this part of the picture, lawyers, ethicists, and tech are talking to one another, but it's a difficult, problematic conversation. Right, now we come to the third and crucial part of the picture, which is Toma and Katrina have been really already very much involved in this part of the picture. Now, in this third part of the picture, Law 3.0, the crucial moment for lawyers is when they begin to think not only that laws might not be fit for the purpose, which is the Law 2.0 thought, and that we need to have some new rules, but the thought that rules themselves might not be the most appropriate instruments to serve regulatory purposes, and so-called technical measures or technology more generally can be deployed for regulatory and legal purposes. This is this is the moment when the world suddenly changes, because now we're talking about technologies being deployed either in support of our regulatory purposes, but or possibly to about all the regulatory weight themselves. And we've heard again from Cordula in those responses she gave to those in the Q&A there, that she's very concerned to maintain the human-centric thought in relation to technology and its applications, meaning not just that technology should be kind of benign in the way that it looks after human interests, shouldn't do us too much damage, but should be kind of paternalistic technology. No, it's about humans still being in control of the application of these technologies. And when you're looking again for, I think in the Yahli's presentation, I think, or Danny, no, sorry, it was the third presentation, wasn't it? I beg your pardon. It was the idea that we need to be able to track back to some responsible human to account for the technology. Okay. You're looking for the human who is still in control in relation to these autonomous weapon systems. So, what's the picture here, Law 3.0? Well, lawyers are thinking for the first time in a systematic way about using instruments other than rules and standards and principles, non-normative instruments, technical measures, architecture, technology to do the regulatory work. I mean, a couple of years ago, there was chaos at Gatwick Airport when a drone, an unauthorized drone, suddenly appeared at the airport just in the run-up to Christmas. The airport was very busy, major international airport, you know, paralyzed for 2 days because of this unauthorized drone. And the response to that, well, there were two responses. One response was people were saying in the Law 2.0 way, the rules are not fit for purpose. We need to extend the exclusion zones around airports, keep drones out. But the other response, which was the interesting one, typically Law 3.0, was can't we have some kind of technological fix here that will be the solution to our problems? So the turn from Law 2 to Law 3 is that in Law 2, technology looks like a problem, a challenge to lawyers. In Law 3, it looks like part of the solution. And that means that law now starts partnering with tech. And we've got law tech and reg tech coming out all over the place. And of course, tech, because it's being partnered by law, because, you know, law is making overtures to tech to come up with smart solutions to these regulatory problems. Tech inevitably is involved in a conversation with law and trying to find ways to assist law to do the things that law thinks might be possible. What you don't see here is who is really pulling the strings. Where does the power really lie in that relationship? That's one of the $1,000 questions. And what about ethics in all this? Well, law also has an interest in partnering with ethics. as indeed, of course, does tech. Yeah, in fact, it's all very cozy in Law 3.0 on the surface because everyone's kind of cozying up to one another. It's about coalescence of law, tech, and ethics. It's about partnering. And well, I mean, in law, actually, for some time, there has been in some areas, particularly medical law, the thought that you can't do medical law without also partnering up to medical ethics as an outside, something that's normally external. I mean, something in law 1.0 would be absolute heresy, the idea that you should be partnering up with ethics in this way. But there have been, certainly in the British jurisprudence, many instances, and 5 years ago in a case called Montgomery, which medical lawyers here think is an absolute landmark precedent in English medical law. The Supreme Court was very keen indeed to be guided by the professional ethics, something external to law, to bring informed consent procedures in law in line with professional views. So yeah, I mean, now this is still a developing picture, I think, and this is moving very rapidly. Very difficult to know exactly what is going on in Law 3.0, except we're all talking to one another, and we're all kind of, as I say, thinking about partnering and technical solutions. So, the tech people are also talking to the ethicists because, as we've heard, ethics by design is something, privacy by design or whatever it might be. Can't we design that into the processes or into the products in ways that make them ethically clean and compatible? Now, I don't know quite what to make of this mix, except I think it's extremely worrying. People sometimes misunderstand my interest in technology. It's not that I'm a technophile or a technophobe. I'm pretty agnostic about this, but it does concern me that I think there are two things that do concern me. And these are the big questions, really. One is, can ethics survive as a critical kind of commentary on what we ought to be doing when it's sandwiched between law and technology in the way that Law 3 seems to me to be putting? Does ethics have any future here? And of course, there is, I have to say, a crisis in ethics because, I don't know well, in some of the bioethics literature, people are talking about bioethics not, having lost a sense of direction. It's just become a kind of public relations exercise where it all rests on process. We don't really have any commitment to kind of line principles anymore. So what's the future for ethics? I mean, that's one of the questions here. Another question is, well, it might seem like, well, ethics surely has a future because we are so uncomfortable about so many of the things that technology puts in front of us. Aren't we ethical reservations about this? And the big choice, which has already been, I think, expressed here, that I think we face in this century is between a mode of governance which does make self-governance by humans. It is still self-governance by humans, as opposed to governance by machines and technology. This is the choice. And the problem is that self-governance by humans is imperfect, a long way short of perfect, very unsatisfactory in many respects, very risky kind of enterprise, but it is essentially human. The problem is that it's kind of got away with this, our respect for law and the authority of law and the rule of law, because the alternatives that we've been thinking about are conspicuously worse, where there's no kind of order of law, terrible order. And laws had an easy pass on this. But if governance by technologies actually does governance better than the imperfect human enterprise of law, then we have a much more difficult choice, because some people will say, well, you start putting AI into the criminal justice system, and all of a sudden that looks like a more effective kind of form of governance than when we humans do it in our imperfect way. And that conversation is going to rumble on for sure, because some people will be skeptical about what technology can deliver in this way, and others will be much more optimistic and upbeat about it. But I think the crucial point is that it's not just governance by technology, governance by smart machines. It's not just a better version of law. It's a completely different mode of governance. This is the point. And what we humans have to be very clear about is whether we want that or whether we want something, you know, whether we want to hang on to our imperfect human governance. And something else just to throw in the mix here. Just look at the way these terms like trustworthy, autonomous, respect, all sorts of terms that we use for human interactions, you know, distinctively in context where we humans are doing our human things, are now being transferred across to technologies and machines. I mean, and, you know, responsibility, accountability. There's a great book about online dispute resolution in which the authors, I mean, I agree with almost everything they say about the virtues of technology and opening access to justice and so on. But they say at one stage we could even modify our concept of justice, you know, as we become more technological in our approach. No, I don't think we should be trying to modify our concept of justice and trust and humanity. No, we are what we are. We're not perfect, but this is part of the human condition. And final thing, sorry, just finally, what's missing in all this big picture is, well, while we're busy with law and ethics and tech, we have rather parochial concerns still, even though we're all talking to one another. The thing that we just miss out systematically is the preconditions for human social existence. It sounds rather fancy, but I mean, the preconditions for humans to exist in the first place. So, you know, if what we're doing in law and ethics and technology is compromising those conditions, and in the Anthropocene, we're doing it massively, then we need to stop that straight away. But also, we're compromising the conditions for humans to exercise their capacity as agents, to have a sense of who they are, to do their own thing. Surveillance societies are incompatible with that. You know, we should be totally intolerant of these technologies, which are threatening to compromise these conditions that are part of the global commons. I mean, I think, you know, when we're talking about AI in autonomous weapon systems and how to have tech controlling tech, we shouldn't have these weapon systems in the first place. You know, to be kind of casual about it, it's just, yeah, it's just ludicrous to me. But of course, this is very idealized. But you know, this is what's missing. If you want to know where the terra firma for ethics is, or for law, or for technology, it's with the maintenance of the global commons. That's where we should start our thinking. We can have our own particular community with our own values, but let's worry about the global commons and what's happening to that. Yeah, well, that's it. Sorry, it's a bit of a rant. But, and I apologize if I talked too quickly for you there, but in 15 minutes.
Yeah, okay. No, you did great. Thank you, Roger. And you were able to cover a lot of ground, and it's actually a very useful way also to conclude the conference, because you did bring together a lot of different layers of regulation. And I think it's interesting. I mean, Tomer talked about the new AI regulations of by the EU, and in fact, you do have also there this idea that you know, some areas are dealt by law and some are dealt by codes of conduct, which may have to do more with ethics than with law. And then technology itself plays a role in the sense that you have, I mean, some of the mechanisms are geared towards examining robustness or technical cybersecurity stuff, which is perhaps more about the strength of the technology. And of course, the fact that you have also machine learning as part of the process only indicates that the borders between the different categories are going to be mutating as you go along. And perhaps even if one had a certain vision at the get-go about what is the, what is the impact of the technology and what is the level of control exercised by humans over this technology, I mean, 5 years later, it may be a very different, I mean, the genie may have left the bottle. I mean, I'm using metaphors, I guess. We're pretty much out of time. I'm gonna use my prerogative as chair to take 10 more minutes because we did start a bit late. So maybe we can take like 2 or 3 questions and then ask the panelists maybe to reflect either on one another's interventions or on the questions. So Amnon has indicated that he has a question. If anyone else wants to do so, please write so in the chat, and I'll give you the floor. So please, Amnon.
Thank you very much. This was a fascinating panel as well as the previous one. And indeed, it's a wonderful conclusion to stuff we also talked about yesterday with respect to regulation by the business. And I want to tie it together by suggesting that perhaps we should revisit Niklas Luhmann's notion of system theory. I know I'm not a Luhmannian or Luhmanniac, as some people who engage with Luhmann turned out to be. But I think there is some value in understanding that the human condition or the social condition is not distributed in a random way, but it's rather clustered around some sources of meaning that have internal logic. And again, you don't have to be strictly Luhmannian in order to approach this. And then introduce two systems in addition to morality or ethics and science, technology, and law. And these are systems which talked about slightly today, but also yesterday, and this is bureaucracy and the market. Because there are market forces here which partly raise serious ethical concerns. Part of the reason we have ethical concerns is not just because it's technology, it's because it's business-driven technology or market-driven technology or bureaucracy-driven technology, which was the previous panel, because there is a bureaucratic logic that also drives technology. Technology doesn't just evolve in and of itself. So it ties back to the notion of what do you want to do by design within technology, what you want to do within business, because business can also be regulated qua business. And then you talk about the economic incentives there, and that will have impact. What you want to do within ethics itself and what you want to do in law. So I think, and again, I think Katrina was sensitive to that, because when Katrina introduced this intermediate body in between the user and the platform or whatever that may be, or the state, doesn't matter. I think she was worried also about relative capacity, which comes with money, but it also comes with other forms of capacity to deal with this AI, which I think is missing from the discussion. So I think one way to think about it is to identify the systems and then to look at it cross-system, if we want to think about the future conference. That was my observation.
Yeah, I think that's a great point. And also with the AI regulations, you have this, with the notion of transparency. I think there is a certain point in which the regulator has given up on the ability of ordinary people to understand what's going on. So you have to delegate the idea of transparency to some intermediate level of expertise that would be able to exercise some control over this. So we're no longer talking about individuals controlling the machine, but rather delegated, power of other individuals. I saw Dustin and Elad also seeking the floor, so maybe we'll hear those two interventions and then we'll wrap up. Dustin, please.
Thanks. So I was really fascinated with the panel, and Katrina, I had a question, which is, to what extent the approach you are considering may or may not be transposable to the armed conflicts context, in particular the international legal regulation of it, given the very different nature and character of the legal framework and the governance framework, really, for armed conflicts, given how closed it is for parties to an armed conflict and not wanting to expose themselves to the types of external and sometimes even internal layers of scrutiny, and whether or not there might be some useful analytical, normative, or descriptive work there. And on the last, I find it very useful with Roger's, 1.0, 2.0, 3.0, all of which are on view at the GGE on autonomous weapons. Some states say we are only talking about law and can cite chapter and verse on each of the legal provisions, all the way up to Cordula and other colleagues in some states saying there's certain normative commitments underlying the legal rules, principles, and norms, and that we need to adapt the technologies. And it's a very fascinating discursive space with extremely high stakes, and one that I hope that we're able to transpose some of the insights from the domestic and sort of more private sector governance frameworks into the legal regulation of armed conflict. Thanks.
Thanks, Dustin. And Elad, finally.
Thank you. This was really fascinating. One quick question, a quick thought. I'll start with a thought. I think that the question that kind of flew over both panels was why are we so skeptic about governance by technology? I think Gary alluded to it in his question in the previous panel, and it might be the case that the technology will generate better governance, better decision making than our own human governance, And nevertheless, we're still very suspicious of the technology and don't trust it, not in the IHL context and maybe not in other governance contexts. And I think that the reason for this might be that when our imperfect officials are making mistakes, they're transparent to us. We can scrutinize them. We can try to understand where they go wrong. Whether the technology is kind of a black box. We're providing all this data and we get answers. And even if the answers are on average more correct than the human decision making, we have no idea to how to identify what goes wrong when it goes wrong. And as AI will become more and more sophisticated, and I think that this will be more and more of a black box, that you just kind of get an answer and don't know how you can remedy that. And I think this is maybe the source of the concern, and maybe the challenge for using AI for governance will be to try to penetrate that black box and identify better where things might go wrong. And my question to Tomer is that I think that your idea in theory is very interesting, and I look forward to read the paper. But I think that one concern is that try to regulate the AI of how social platforms making decisions, how they disseminate information, is really going to the core of their business in ways that, and this is the biggest economy in the world right now. And do you trust governments, do you trust officials to go into these all delicate issues and try to find some standard of how the AI decision-making in an internet platform should work? Because the implications for innovation, for the business itself, could be disastrous. Thank you.
Okay, thank you, Elad. Let's go back now to the speakers. Maybe we'll do it in the same order this time. Maybe Tomer briefly, and then Katrina, and then the final word for Roger.
Okay, thank you, and thank you for the question. There's a lot to say. I will try to be really brief and maybe to connect the point. So first of all, I'm a big fan of law, and I think law should stay as a space, important space for a normative ordering in which interpretation, in which ambiguity as a feature and not a bug take place. I think it's even more important in front of this technology to have a space for interpretation, for which taking the dynamic things that happen in the world and try to understand them and to put them into boxes, but with interpretation and not with binary kind of thinking. So I think, I don't think that we should transform law into technology. I think we should protect law in this space, but sometimes using technological tool in order to achieve it, but still like and protect this field. That's first of all. Second, to an add question, yeah, I think all this problem of hate speech, disinformation, all this stuff are problem that comes from the business model. And we can just speak about the oversight board and this decision and that decision, but the overall problem, the scale of the problem come from the business model. And I don't think it's a question of trust in government, but I think if we want really to approach those issues, we need really to approach the business model and the way the business model directs the algorithmic regulation or the AI regulation. Just to conclude, to Amnon, I think one of our problem right now, that if we take Lawrence Lessing of the 4 forces, normative forces in the cyberspace, so the problem now is again that those market forces in a way enforce their own logic on the 4 part of those issues of the system. Their logic is the logic of the market, their logic is the logic of the technological architecture, and their logic is the logic of ethics, as Roger told us. And the logic is also have extremely power on the logic of law because of the lobbying that Elad said. So maybe one of our mission is to reinvent those separate system of lumen in this space.
Thank you, Tomer. Katrina?
Thank you for this panel. Thank you for the questions. So Dustin, thank you for the specific question. Unfortunately, I don't have enough background and conflict to really answer it well, but I'm very interested in whether there are analogies there that can be drawn. I just want to close with maybe sort of a counterpoint to what I was saying earlier. Despite being a technologist and having advocated for the role of technology in regulating technology, I want to say that I very clearly do not think that technology can solve all of the problems in the space itself. I think there is a clear need for the role of other toolkits, including the law. And one of the most interesting and exciting challenges to me in this space is understanding, in some sense, a sort of reference to Roger's points, understanding how to build systems that have all of these components and have them working together, and how can technology understand its limitations and scope itself appropriately and be part of the solution in the places where it's best suited. How can technology interface, as Tomer was alluding to, interface well with these other pieces of the solution that embrace, for example, ambiguity, which is so inherently anathema to technology and technologists. But I think that there are really deep and interesting questions at these interface points, and in how we develop common language and solutions that really bring the best from all of the toolkits. So thank you.
Okay, great, Katrina. And Roger, final sentences?
Yeah, well, thanks, yeah. Well, like Tomer, I'm a fan of law. But I also appreciate the benefits of technology. But above all, I think ethics is what really matters. Law made a fundamental mistake, I think, in putting itself adrift from ethics. You know, this idea that we could focus on thinking like a lawyer by putting ethics to one side. I think that's a huge mistake. And we have to understand, I mean, the only reason to respect law is if it's trying to do the right thing. It can't divorce itself from ethics. So much of what passes as law is not ethically guided at all. And I think ethics has to be the dominant part of this triad of law, ethics, and technology. Technology too, for me, I mean, it's great. Technology is a tool, but unless the tools are being applied or developed for the right reason, then, you know, and it might be that reason is to serve humanity. Well, I don't see it has any virtues. So although, you know, ethics is problematic in that people have very different things, I do think that has to be the dominant part of the relationship. And it's the part of it which is the most endangered, I think. You know, that's the part that's going to drop off the map if we're not very careful.
Okay, thank you very much. I want to thank all panelists, as well as the organizers for this event, Tal, Lili, Dalit, Amnon, from our colleagues from Haifa and the colleagues from Hebrew University. This was very interesting. Of course, these are not usual times, and we're very grateful that you were able to join us. I mean, for us, this is maybe one way to deal with a very difficult and painful situation, is to, you know, not give up, you know, on continuing some of our work. So it's not fully business as usual, but we are trying, you know, to keep some level of normalcy and in this very deep, in very complex reality. So I wish everyone here a safe evening, and hope to see you in future activities. Thank you.
Thanks, Yuval. Yeah.
Thanks, everyone.